Good morning.
Good morning.
Each side will have 15 minutes to present your arguments, and you may reserve up to 5 minutes if you so choose.
I would like...
Just let me know, please.
Okay. I would like to reserve 5 minutes.
Okay. Thank you very much.
Good morning to the panel. First of all, appreciate your time and consideration. This is a case that was decided on summary judgment. The focus of the appeal is that it was an error to grant summary judgment, particularly in light of the strong authority from the courts, including the House Supreme Court, that the determination of the scope of an agency between a broker and an agent is a matter for the trier of fact. An error that I believe the trial court made that plays into that a summary judgment motion should not have been granted is that licensing law provides two things. Any activity involving the exchange of money and activity for real estate, particularly for an agent, requires the involvement of a broker, the supervision of a broker, and that the broker be responsible for those actions. As stated in the brief, there's administrative law confirms that when a real estate agent is engaging in property management services, that is also required to have a license for the property manager. And as with any activity of a property manager, that agent must be acting under the supervision and control of a broker. In this case, the trial court essentially held that Caldwell Banker Hunter Realty could circumvent the licensing laws by having its broker, who's Mark Kelly, the managing responsible broker, the individual with the broker's license at the Caldwell Banker office. He simply had the agent, Susan Gerbec, who we've worked with for years, set up her separate LLC after meeting my client. There was no separate broker, no separate license. The only license at issue here that existed was Gerbec's license that was held with Caldwell Banker Hunter Realty. And so I think the decision by the trial court actually has, I would say, a larger effect than on this case. It's basically a stamp of approval that a broker can circumvent its responsibilities under the licensing laws by simply having its agents go out and form separate entities, and that was clearly not the intent.
How do you respond to the fact that really there's not a lot of consideration here? There's no money really flowing back and forth.
And that's a good question. Obviously, it's the heart of this, and the trial court weighed heavily on that. I would say this, that you've got an arrangement here where you have Caldwell Banker operating out of the Turkey Foot office. The owner of the building is an agent at the Turkey Foot office. Susan Gerbec is an agent in that building, and that Caldwell Banker is using Susan Gerbec to pull business into the Caldwell Banker office.
Meaning the properties that she manages.
Correct. Yes, she manages properties. She also sells properties under the license of Caldwell Banker Hunter Realty.
But there are two separate functions. The property manager function might have different requirements and credentials as opposed to a salesperson or a broker.
That's correct. And I would just suggest that I'm referring to an exhibit in the briefs that when we have a Caldwell Banker website that promotes Susan Gerbec, Caldwell Banker's name, Susan Gerbec, Realtor, Caldwell Banker Hunter Realty, and the very first line item promoting her is Property Management Specialist since 1996. This is Caldwell Banker's phone number, it's their name. They're telling the world that we are a property manager and here's our agent that handles that activity. And in this case,
so you're in essence, you're saying that that alone is enough to impute to Caldwell Banker some obligation to control and monitor Ms. Gerbeck's function as a property manager?
I would say this alone is enough to require a trial.
Is or is not enough?
This alone is enough, but I believe there's more, which I'd like to get into.
Okay.
I believe it's enough because the threshold question is was Susan Gerbec promoting the business of Caldwell Banker Hunter Realty? And when Caldwell Banker puts her on their website to promote her business, I think that satisfies that requirement. And to follow up on the consideration issue, Susan Gerbec is paying to have this advertisement on Caldwell's website. She is paying Caldwell Banker to represent to the world that Caldwell Banker provides property management services. She's paying rent to be in that office. She's bringing in business, selling other properties, bringing in commissions. She is working on REO listings, bank-owned properties with other agents, Linda Somerville. All of that activity is generating revenue for Caldwell Banker Hunter Realty. And my reading of the cases, including 2014 case of the Auer decision, is that it's not, the question is not, is the broker getting a check every time the agent, the property manager, collects a property management fee. It's a much broader inquiry than that. That alone does not answer the question. And when you have a situation like this, where there's just really a creative structure in place to compensate Caldwell Banker and to have an agent of theirs managing properties, I think it's form over substance to say that just because Susan Gerbec does not pay a percentage every time she gets a management fee, that should let the broker off the hook. I think that's a sense of wrong message to the industry. These are the questions that I believe a jury should get to inquire about.
I'm sorry, I'm going to have to turn this all the way off. I cannot seem to make it stay quiet.
We're just talking about that. Electronic stuff.
Is paying an advertising fee to be on the website, is that sufficient consideration? It's undisputed that happened. Is Caldwell Banker getting commissions from Gerbec's sales overall when she's getting business because of the way she promoted on the website? Is that enough to create an issue of fact? Is the fact that Somerville, an active agent with Caldwell Banker Hunter Realty, is using Geraldine Carter's tax identification number, which he only could have gotten from Gerbec while Gerbec was managing the properties, is the fact that that tax ID number was used a year or two later to help sell REO listings that are listed by Caldwell Banker and generate commissions to Caldwell Banker Hunter Realty. You know, is that enough? And I would just suggest that it's certainly enough to have a trial, to allow Geraldine Carter to let a trier of fact consider all of this, answer these types of questions, and decide if the broker is responsible or not. The fact that the property management files were actually, the property management clients were sold by Mark Kelly to Susan Gerbec just before he transferred, at around the time he transferred his license to Caldwell Banker Hunter Realty, and then he continued to refer accounts to Susan Gerbec after that, shows that the mutual relationship and you know, essentially a partnership between these two. And very important is the fact that Geraldine Carter did not reach out to Susan Gerbec. Geraldine Carter reached out to Mark Kelly. And at that time, Mark Kelly was the broker for Caldwell Banker Hunter Realty. Mark Kelly is the one that then introduced Geraldine Carter to Susan Gerbec. And so in terms of the question, does Caldwell Banker Hunter Realty, did they promote the business of Susan Gerbec, which is a very important question according to all the case law. I can't, it's hard to think of a way that they did not support her. They sold her clients, they referred her clients, they propped her up on their website as a property management specialist, above all, and they continued to cooperate with her. They had her working with other agents to sell REO properties, and in the process of doing that, she was clearly committing fraud. And so, in my assessment of this, you know, does Geraldine Carter win? I believe so. But what I'm really saying here is she at least deserves to have her day in court. There's I think, clearly enough facts here where this case should not have been thrown out on summary judgment.
May it please the court, my name is Colleen Mountcastle. I'm here on behalf of Caldwell Banker, and I ask this court to affirm the summary judgment decision in its favor and the denial of the motion for reconsideration. The crux of this case is whether or not the court could determine as a matter of law that there was the actions taken by Gerbec and her management company, S&C, fell within the scope of employment. The Ohio Supreme Court's Byrd decision is instructive. It talks about whether or not those independent actions of the agent benefited the employer. In this instance, using the words of the appellant on page 7 and 8 of the appellate brief submitted in this case, Carter summarizes that the alleged misconduct and fraud consisted of duplicate payments to the handyman, Mr. McAllister, fabricated invoices of subcontractors, including the handyman, Mr. McAllister, allowing tenants to rent off of the books, diversion of revenues in escrow or from escrow, forging Carter's name on Section 8 housing applications, and appliances disappearing from the units. When you look at the own words of Carter in the appellate brief submitted here, not one of those actions benefit Coldwell Banker. And this is important. It's important under the Auer decision. The Ohio Supreme Court did find that there was a question for the jury there. And the reason that it found that there was a question for the jury is there was a direct benefit to the broker under the circumstances of that case. That case fell squarely within the revised code section 473521. And in that case, a sales agent, a real estate sales agent, sold property, and the broker received a commission from the sale of that property. There were several allegations of wrongdoing stemming from that initial sale of property, but first and foremost, the court looked at the fact that the broker received a commission from that sale, and therefore there was a true question as to whether or not it fell within the scope of employment. Simply because this is a real estate transaction, simply because we are talking about agents and the holding of license by a broker, does not take this out of the purview of your standard motion for summary judgment practice. You have to look at the facts to determine whether or not there is a material issue of fact. And here, there is no material issue of fact. That's why the court was permitted under the Osborne versus Lyles decision and this court's decision in Wrinkle versus Cotton to find as a matter of law that there was no scope of agency act taken by Ms. Gerbec. Her actions were self-serving, her actions benefited herself and Mr. McAllister. They did not benefit Coldwell Banker. With respect to the only evidence where there's an attempt to make a tenuous connection to Coldwell Banker, that evidence was submitted after summary judgment was granted in favor of Coldwell Banker. That evidence actually came from actions that also took place after summary judgment was granted. Even if this court or the lower court were to consider the Adair affidavits and the information attached thereto, the actions, the very first action that took place on March 22nd, 2014, and it's the allegation that there was a utility bill that was transferred over to the Carter Property Company for payment. and that there was some connection between that and an agent of Coldwell Banker. That March 22nd, 2014 date is important because the trial court had already granted summary judgment on March 20th, 2014. So at best, those actions certainly took place after the complaint was filed in 2012. It certainly took place well after the court granted summary judgment. So there's no question that the court did not abuse its discretion in determining that that information was not sufficient to overcome the summary judgment and to support a reconsideration of its prior decision. With that being said, Your Honors, we respectfully request that the trial court's decision granting summary judgment in favor of Coldwell Banker be affirmed on appeal. Thank you.
Thank you, counsel. You have roughly 4.5 minutes.
Thank you.
Thank you.
I would first like to address the point made, which is a valid point, about the direct connection between the actions taken by the agent and how that benefits the broker. The most direct action and clear benefit to the broker is Gerbec using the tax identification number of Geraldine Carter to have utilities turned on, kept on at a REO listing of another Coldwell Banker agent. Clearly there's a benefit there. And I think it's up for the jury to decide the extent of the benefit and what that means, but there's clearly a direct benefit there. And this evidence was truly not available until the business manager for Geraldine Carter received the bill in the mail shortly after the summary judgment was granted. I think this is the reason there are rules allowing a motion after a decision's been made to open the case back up. I think this fits perfectly within that. This is clear evidence of fraud. There's no question about that. And I believe enough evidence of a benefit to Coldwell Banker on a realty that alone should, that the court should have granted that motion to reconsider.
Well, I just want to clarify, if possible. When you say that's the reason why the court has the ability to open a case back up, it can only open the case back up if it's a final order and you file a 60B, or if it's an interlocutory order and you can then ask the court to reconsider.
Correct. And I considered it an interlocutory order because there was no final order at the time I filed the motion. As I put in my motion to reconsider, notwithstanding the fact that when it's an interlocutory order, you do not need new evidence, I attach the evidence that I have the new evidence, and the court subsequently determined that the case had been settled and that, for all intents and purposes, the motion should have been a 60B motion. And that it didn't change my argument. My argument was that this bill, which was, to me a smoking gun, that the tax ID number is being used, not just by Gerbec, but with another active Coldwell Banker Hunter Realty agent, Linda Somerville. And I just think to ignore that evidence, I don't understand how the court could do that. As far as the connection for all the other actions, I would just suggest that if a broker wants the benefit of an agent and what they bring to the table as far as business, and they promote that person as a property manager, the broker clearly wants to have the ability to let the community know it handles bank-owned properties, distressed properties, which, given the economy and the environment in the real estate market, that is becoming a very important aspect of any broker to survive, to deal in distressed properties. It's not an accident that Coldwell Banker had that listed as the very first thing that Gerbec did. So for Coldwell Banker to hold her out and to get the benefit of having that aspect, that arm of his business, and then to turn around and say we're not responsible for that is the part that I think would not be good precedent going forward, because it would lend itself to brokers basically saying, we can insulate ourselves from the actions of our agents by simply having them set up separate LLCs and finding a creative arrangement to pay them. And that's really what this was. And I think the as far as a broker goes, there's one responsible individual that holds a broker's license. The fact that that person in this case was Mark Kelly, and he was so involved with everything that Gerbec did, and for purposes of responsibility, everything Mark Kelly did, that is Caldwell Banker taking those actions. So it's as if Caldwell Banker sold the property management clients to Gerbec. It's as if Caldwell Banker itself referred more business to her. It's everything he did, Caldwell Banker Hunter Realty is responsible for.
Let me ask you a question.
Yes.
Let's say we have a company that does business and requires the notarization of many commercial documents or documents with respect to their clients. And for convenience sake, they situate or allow a notary, independent notary, to be situated conveniently on the same premises. And the notary does all of their notary work, but is an independent person and not an employee of the company. Are you suggesting that that would then make the company liable for any errors that the notary might make in the performance of her duties?
I would say if the broker did not know about it, I would say the answer to that is no. I don't think notarizing documents would be the type of function in real estate that the decisions, the case law would say needs to fall under that umbrella of the responsibility of the broker.
And you are out of time.
Okay,
Thank you very much for your presentation. Thank you both for appearing before the court and the arguments that you made. The court will take the matter under advisement, and a written opinion will be prepared and sent to both sides, and you can also check on the Ohio Supreme Court website.
Thank you.
Thank you.